Thank you, Mr. Chairman. Thank you all for being here. During my 30 years in law enforcement, 8 years as a sheriff of a large county in the great state of Texas, I served hundreds of warrants. And to obtain a warrant, I was required a probable cause. And this was to protect the people for violation of their Fourth Amendment rights, and I agree. I wholly agree. And the FBI, on the other hand, has abused its FISA authorities and violated America's constitutional rights. And in several investigations and audits, the DOJ Inspector General Michael Horowitz and Special Counsel John Durham exposed the extent to which the FBI violated its FISA authorities. And for example, in 2019, the OIG issued a 478-page report finding that the FBI has abused its FISA authority to illegally surveil former Trump campaign associate and American hero, Carter Page. The report found 17 significant errors or omissions and 51 wrong or unsupported factual assertions in the applications to surveil Mr. Page. The FBI relied upon uncorroborated information to support its application to surveil Mr. Page because they wanted to keep, in my opinion, Donald J. Trump, the greatest president in my lifetime, from office. And per the report, the FBI cherry-picked facts to support its application, ignored exculpatory evidence, and even doctored evidence presented to a FISA court judge to support its surveillance against Page. The FBI's FISA applications to surveil Trump associate Page were based almost entirely on the debunked allegations in this Steele dossier. There was no probable cause. And I think it's very important that we go through. Mr. Carter Page, what an American hero. 1993. Graduates from the Naval Academy, so wanted to serve his country. He worked as an intel officer for 5 years. And then you go forward from 93 to 2000, he begins working as an investment banker in London, making some money. 2004, gets promoted, moves to Moscow. And that's where things kind of get interesting. 2007, Page becomes an internal energy consultant in Moscow and London. And then in 2008, the CIA, they begin debriefing Page about his contacts with the Russians. 2000 now FBI counterintelligence interview, they interviewed Page, in which Page told them he was reporting information to the CIA. So back in 2009 already, the FBI, the CIA, they know who Mr. Carter Page was. In 2013, some Russian agents, in January 2013, some Russian agents approached Page in an attempt to cultivate him as a source. He rejects, of course. In April of the same year, the FBI records one of the Russian agents complaining about Page because Page wasn't working with him. He wasn't going to do anything for the Russian agents. He's an American hero. In June of the 2013, the FBI interviews Page again. And Page said he was working, and he has spoken with the CIA. And Page agrees to cooperate as a key witness in the FBI undercover investigation of the Russian agents that want to turn him. So he's working, he's doing everything he can for his country, as he has when he started back in the Navy. And then it gets interesting. March of 2016, Page meets with the FBI agents and federal prosecutors about their case against the Russian agents. And one of those Russian agents was found guilty, spent 30 months in prison. That couldn't have been done without Carter Page. Then, all of a sudden, this is where things get really sour. March of 2016, Page joins the Trump campaign as a foreign policy advisor. In April of 2016, the FBI headquarters advises New York field office to investigate Page. A couple months later, in August 2016, FBI headquarters opens investigation of Page and prepares a request to eavesdrop him under FISA. August, the CIA sends a memo to the FBI headquarters and advised the Crossfire Hurricane team that Page was an operational contact for the CIA for 5 successful years, 2008 to 2013, and the FBI does nothing. They do nothing with it. What do we know? The FBI withheld this information from the FISA court, and the court approves the FISA warrant and secretly surveils Page. Wow. Wow. So he's an American hero until he joins the Trump team. And you wonder why people up here feel that the FBI cannot be trusted, and why we say that they have weaponized the FBI to go against the American people, specifically with a dissenting point of view, like Carter Page and Donald J. Trump, and they haven't stopped yet. They continue to go up against Donald Trump, whether it's Mar-a-Lago, whether it's indictments up there with the nut job in Manhattan. It's just horrible what the FBI, we have to rein them in. I will not support the idea of reauthorizing 702 for the FBI until they get their house in order. With that, I yield back.
Thank you. Chair recognizes the gentlelady from Pennsylvania, Ms. Dean.
Thank you, Mr. Chairman, and I thank the ranking member for having this important hearing today, an important moment of bipartisanship and the understanding that the FISA application has gone horribly wrong. It is our responsibility to do something about it. So I thank all of the witnesses for being here today, for your expertise and your historical understanding of where we are and the grave moment that we're in. The Foreign Intelligence Act, FISA, the legislative branch, we're entrusted with making the laws of the United States. It's our job to decide what the rules should be, delineating fair from unfair, safe from unsafe. Sometimes these decisions are straightforward and easily guided by the Constitution and common sense. Other times the decisions are more difficult. It feels like we're in one of those places now with a clear-cut understanding that the abuses of the FISA applications and queries are unacceptable. We know we have a responsibility, as do the agencies, to protect our national security, to protect us against crime anytime we can possibly do it. But we must always protect civil liberties, people's rights to privacy, our constitutional rights. Ms. Goitein, I was interested in your very eloquent history of what's going on here and what has happened. We do need to review the FISA process. What are the most, if you had maybe 3 areas of reform, what would be the most important? I know it's denser than that, but what would be the most 3 top areas of reform?
I've been trying to narrow it down a little bit because I know that that's helpful. It's difficult. There's a lot that needs to be done, but I think I can at least narrow it to 3 buckets. And the first bucket is ensuring that Section 02 works as intended, and that means that it's not a domestic spying tool. For that, we need to have a warrant requirement or a requirement of a FISA Title I order before the government conducts U.S. person queries of Section 702 data. Part of the Section 702 reform also has to be narrowing the scope of permissible surveillance so that the government is not allowed to conduct surveillance of foreign targets who do not reasonably pose any threat to the United States or have any information about a threat to the United States. That is actually a vicarious protection for Americans' privacy, because the larger the scope of permissible foreign targets, the greater the volume of incidental collection of Americans' communications. So that's the Section 702 bucket. Then I would say that Congress needs to complete the modernization of FISA by ensuring that Americans' communications and Fourth Amendment protected information are protected from warrantless surveillance regardless of where in the world the government obtains that information. And then finally, I would say that the Congress has to close the data broker loophole. And while we were on break, the House passed by voice vote a bipartisan amendment co-sponsored by Representatives Jacobs and Davidson, and with a long bipartisan list of co-sponsors, which I'm not going to list because I'm afraid I'll forget someone by accident. But the House passed an amendment that would prohibit the Department of Defense from buying its way around the Fourth Amendment and obtaining Americans' Fourth Amendment protected information by buying it from data brokers. That is proof of concept. Congress can do this, and Congress now needs to do that for all federal agencies.
That's very helpful. Mr. Kiko, thank you too for your testimony and your work on this. We talked about whether to sunset and allow it to expire, Section 702, or to reform it, as we've just had some conversation around that. What are the consequences of allowing 702 to simply expire later this year?
Well, I think allowing it to expire, you're turning over the keys to the to Article 2, to the executive branch. And we've had enough experience to know that even when they have a statute, there's ways to weasel around it. And I just would be very, Article 1 is the Congress. They're the ones that establish the law. And we're going to have to, my experience would be to draft something but you're going to have close oversight. You're going to have to bring the administration to heel, for the consequences of abuse, but also we don't have to have it read as broadly as it is for data purchases and for all this other stuff that they've been somehow figured out to have jurisdiction over. So if you could narrow that but really have tight oversight and also consequences for people and agencies that don't follow what the law is.
I thank you both. I thank you, Mr. Chairman. My time's expired. I yield back.
Thank you. Chair recognizes the gentleman from California, Mr. Kiley.
Professor Shirley, in your statement, you quoted Justice Brandeis's famous formulation of privacy as the right to be let alone, which I do believe is indeed one of the rights most valued by Americans, and that most Americans would be horrified to hear of the government having access to their private communications. There's something really fundamental about this separation between the public and the private, the idea that each of us has a sphere of personal privacy that is inviolable, that goes to the heart of what it means to live in a free society. But sometimes you hear a contrary view that, well, if you're not doing anything wrong, what do you care if the government has access to this? What would be your response to that?
Well, thank you very much for that question. What's interesting about the quote that you just cited is that this was part of the Katz-Olmsted line of cases. And Katz said that the Fourth Amendment's there to protect persons, not places. It got rid of the trespass doctrine as the key test for whether your rights are violated. We've sort of returned to that because the location of a lot of this data, if it's abroad, for example, or it's routed through an international source, suddenly loses its protections as a citizen. So to answer your question, how does that impact you? The answer is that 702 and the abuses under that section impact free speech, associational rights, a host of other constitutional rights, because it creates a chilling effect that if citizens know that their communications are part of a massive data bank that the government can search and piece together who you've talked to, who you sent to, you begin to live in this fishbowl society. That impacts us as citizens. It impacts how we exercise rights, which is what Brandeis was referring to.
And Mr. Scherer, or Mr. Scherer, I should say, right?
Scherer, yeah.
Scherer.
Like the singer.
We've been talking a little bit about how this right was, put into our Constitution by our founders in the form of the Fourth Amendment, and how a lot of the jurisprudence and our understanding of the Fourth Amendment is rooted in this idea of a reasonable expectation of privacy. And so we've heard that the law, at least as far as the courts are concerned, is a little bit unsettled when it comes to how that applies to the situation we're talking about today. So in your view, is that a lens that Congress should look through when deciding what to do about FISA, the reasonable expectation of privacy that Americans have, and how should that apply to the gathering of information under Section 702?
Well, 2 points. First of all, while Congress should take account of what the courts have said on the application of the Fourth Amendment in this setting, I don't believe, with all respect, that you as members of Congress should feel bound by what the courts say. All of you, I apologize if this comes across as a lecture, but all of you have taken an oath to support and defend the Constitution of the United States, not the interpretation of the Constitution by some federal district judge in the Western District of Wisconsin or wherever he or she may be. And you have the ability, and I think the right and the duty under the Constitution, to reach your own conclusions about what the Fourth Amendment requires. But secondly, even Congress has an important role to play in determining for the courts what is a reasonable expectation of privacy, and when do the people of the United States have a reasonable expectation of privacy. And even if some courts don't think that we have a reasonable expectation of privacy in our electronic data, which, as we've heard, may get sold to data brokers and then sold to other people, Congress can step in and say, no, we think the people of the United States do, in fact, retain a reasonable expectation of privacy in their private data, even if it's held by Google or Amazon or somebody else. And we, the Congress of the United States, believe that Americans retain an expectation of privacy in communications that have been collected pursuant to 702.
That's right. And so could we take the analysis a step further? And so I think most Americans would understand we live in a dangerous world. Intelligence gathering is very important. Sometimes aggressive tactics are needed. And it's possible that on occasion, information can be incidentally collected. So the question becomes, once that information is there and in the government's hands, what do you think is the reasonable expectation of Americans as to what is done with that information, how long it's kept, who can access it? Because that's really, I think, the question when it comes to reforming FISA that we need to consider.
Well, certainly, and if people have not expressly consented to have that data collected and put into the 702 database or wherever else it goes, I think it's fair to say that they should retain an expectation of privacy in that data, even if somebody else has it, and therefore Congress can say, consistent with the Fourth Amendment to the FBI, if you're going to search that database of purchase data, or if you're going to search the database of 702 derived information, you need to get a probable cause order from a court.
Thank you very much. It's great to see the bipartisan agreement on a lot of these principles, and I yield back to the chair.
Thank you. The chair recognizes the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Having practiced criminal defense law for 27 years and acted as a judge for 12 years prior to my 17 years now in Congress, I understand Fourth Amendment principles and understand the concept of a reasonable expectation of privacy, but I cannot wrap my head around the concept of a reasonable expectation of privacy in data that has been acquired over the open market by anybody who wants it, like Russia or China or Iran or North Korea. That's data that is purchased every day by our adversaries. Why should not our own government be able to acquire that same data that we certainly have no reasonable expectation of privacy in, given the fact that it's on the open market? However, we in this country can certainly rely upon the Constitution and its principles to protect our privacy, especially when privacy concerns bump up against security concerns. We've lived through harrowing terrorist attacks on U.S. soil and through attempts by foreign actors to meddle in our national elections. That's why, while taking affirmative steps to protect our civil liberties, we must give our intelligence community the tools it needs to protect us. Section 702 of the Foreign Intelligence Surveillance Act is one of those tools necessary to protect our national security. Due to the classified nature of much of the work that's done under Section 702 FISA authority, Americans will never know how it has kept them safe, the degree to which it has kept them safe. They will, through politicians, hear of problems with implementation of the legislation and demonization of those who would access that information to protect us. In the real world, law enforcement can patrol the street to monitor suspicious activity. They don't need a reasonable expectation of privacy in order to be out on patrol. We need to bring real world processes to the cyber world. And Section 702 allows us to do that, letting law enforcement patrol the information highways to neutralize threats. However, just as cops have certain limitations, the intelligence agencies have limits on their ability to search the Section 702 database when it comes to U.S. person identifiers. If the agency's investigation is related to national security, then a database search using U.S. person identifiers is allowed when the agency believes it is, quote, reasonably likely, end quote, that such a search will retrieve foreign intelligence or evidence of a crime. And if the agency's investigation is unrelated to national security, then the agency must get an order from the Foreign Intelligence Surveillance Court before it can search the database using U.S. person identifiers. In the past, it seems that the FBI has fallen short due to, among other things, lack of proper training on the limitations imposed on them by law. in this day and time when politicians recklessly demonize government in general and the FBI and DOJ in particular, the public is susceptible to claims that the FBI willfully defies the law, abuses its power as a regular course of conduct, and as some have argued, is generally, quote, bad. I respectfully disagree with the assessment of the 38,000 employees of the FBI, including special agents and support professionals, many of whom put their lives on the line every day to protect us from danger, both foreign and domestic. And I would also point out that it's not about bringing this administration to heel. These FISA excesses existed during the Trump administration and before. In the past, I'm heartened to see that the Department of Justice is working hard to improve agency compliance with the civil liberties protections in Section 702. I look forward to continuing the dialogue on how we can improve compliance with Section 02, how we can improve the Act itself. And with that, I will, well, I don't have time.
Yeah, you can't yield anything back. You don't have any time left. But thank you, though. Yes, I knew you did. And we'll now recognize the gentlelady from Florida, Ms. Lee.